evening. Okay, let's continue with the discussion of estate and interest in land. Now we have learned last week about legal estate, equitable interest. And now we are coming to a new aspect of the so-called legal estate equitable interest, namely the format requirement for creating and disposing of such interest. Now, if you want to, if you still remember, this tenancy easement charge can exist as legal estate, and they are also capable of existing as equitable interest, whereas land covenants could only exist in the form of equitable interest. Now, if you want to ensure that, say for example, a list is an equitable, is a legal estate, then you have to comply with the format requirement or formal requirement under CPO, Conveyancing Property Ordinance. Section 4.1 of CPO stipulates that a deed is generally necessary to create, extinguish, or dispose of a legal estate in land. Now you should know by now what is a deed. A deed is a formal document that is signed, sealed, and delivered. So if you want to create a legal estate, you must make use of a deed so that they can become a legal estate. Now, of course, there are exceptions to this general rule. For example, if the legal estate is created or transferred by operation of law, we'll soon come to an example of that in the next chapter, next lecture. But in the section itself, section 4, subsection 2 of CPO, provides a very, very important exception to the requirement for a deed. Now, and it deals with lease or tenancy. Any grant, you grant a lease to, for example, government grants a lease to a lessee, dispose of, to transfer a lease to another person, or surrender. Surrender refers to the tenant under the lease give back the land to the landlord and terminate the lease before it expires. Now, in other words, creating and disposing of a lease must be indeed under section 4.1, except that the lease take effect in possession. Possession refers to the perpetual rights of possession to land, and for a term not exceeding 3 years. So, a lease is a terms of year absolute. There is a definite beginning and definite end. And this particular term between the beginning and the end, if they are not exceeding 3 years, at the best rent reasonably obtainable. So it refers to the market rent of a premises, and without taking a premium. It means the landlord does not receive a sum of money for granting this lease. So, the exception is a short lease, or usually we describe a short lease as tenancy. A short tenancy, not exceeding 3 years. And the rent is the real rent, market rent, but not say $10, $1 for you to stay for the whole month. That would not be falling into this particular exception. Market rent, 3 years, and the tenant is not required to pay a huge sum of money for entering into the land for occupation. So this three factors, 3 years, best rent or market rent without premium. If you are talking about a list fitting all the three conditions, then it is possible and acceptable to create a list or tenancy without using a deed. In fact, you can do it orally. Now, if you remember your law and contract, oral contract is enforceable. But if you want to create a list longer than 3 years, then you cannot do it orally. Only when the term of that lease or tenancy is less than 3 years. Now in Hong Kong, therefore, if you are talking about domestic tenancy, in most cases it will be 2 years, or at the most 3 years. So in most tenancies in Hong Kong, you can take advantage of this exception. You do not need a written tenancy agreement. Now, so that is about the lease itself. See Section 3.1, same ordinance, Conveyance and Property Ordinance, requires contracts for sale or other disposition of land be in writing and signed by the parties subject to Section 6.2 of CTO. Now, we are not talking about the lease itself, but the contract for creating the list or disposing the list. Now in Hong Kong, all lands are leasehold. Therefore, the so-called sale and purchase of real property in Hong Kong actually is captured by Section 3.1. Now, for all sales and purchase, of course, it all begins with a contract. If you want to purchase a flat, you go to the estate agency, ask them to help you to look for a flat, and then after you find the flat, suitable for you, then you will sign a preliminary agreement. Why you have to sign? Because Section 3.1 requires contract for sale or other disposition of land be in writing. It must be in writing and signed by the parties. Let the vendor purchaser have to sign it. Of course, there is some exception. Now, again, Section 3, Subsection 1 is qualified by Subsection 2. This section refers to Section 3, applies to contracts or other dispositions whenever may and does not affect the law relating to past performance or sale by the court. Now, these are other exceptions. If you are talking about sale by the court, for example, someone owes another person's money and the creditor got what we call a legal a charge from the court, and he would be able to apply for selling the property and collect the sale proceeds to satisfy the debts. Now, if the sale was ordered or by the court, then we don't need any contract in writing. Or past performance is another concept that would be the case when, even though you have an oral contract, but you already perform part of it. For example, the vendor allow the purchaser to physically occupy the land or flat in question, and the purchaser already make part payment of the property to the vendor. Now, if you have this kind of part performance, then maybe it is not necessary to have a written contract. Otherwise, it is a must to have a written contract signed by the parties in relation to sale and other disposition of land. And remember, we have subject to section 6.2. What is 6.2 about? Section 6 of section 2 said nothing in section 3 or 5, later on they'll come to 5, or in subsection 1, that is subsection 6.1, shall affect the creation by peril. What does it mean by creation by peril? Oral creation of leases. Now, taking effect in possession for a term not exceeding 3 years, whether or not the lessee is given power to extend term at the best rent, which can be reasonably obtained without premium. Now, this sounds familiar to you because we already saw that in section 4, subsection 2. A term taking in effect, a lease taking in effect in possession for a term not exceeding 3 years at the best rent reasonably obtainable without taking premium. So, section 6.2 just echoes section 4.2. Now, even though we are not talking about creating or disposing a legal estate, we are just talking about the initial stage of contract. You still need something in writing and signed by the party, except if you satisfy all the three conditions, term less than 3 years, best rent without premium, then, as I said earlier, that legal estate can be created orally. The same applies to the contract. Contract can also be created orally if you satisfy all the three conditions. Now, section 5 is talking about equitable interest. Okay? Equitable interest in land. No equitable interest in land can be created or disposed of except by writing, signed by the person creating or disposing of the same, or by his agent, or by will, or by operation of law. So, not just for legal estate, but also for equitable interest. If you want to create an equitable interest or transfer an equitable interest, you must do it by writing and signed by the parties concerned. Of course, you can also do it by will. When you possess a real property, you want to transfer this property to your son or daughter after you die, then you can do it by will or by operation of law. So, and of course, by operation of law would not require any writing. Now, therefore, except you can take advantage of this particular exception, a term not exceeding 3 years best market rent and without premium, or contract for creation or disposing of interest in land, legal or equitable, it must be by writing and signed by the parties. And for the legal estate, not just by writing. The writing has to be done in a formal way to make a deed, written document has to be signed, sealed, and delivered. Now, all this requirement of having some writing as the evidence for creation and disposal of interest in land is because land represents some very valuable interest. And the common law court want to be sure that no fraud is being carried out by any party. If you just allow oral sale and purchase of land, then if there is any dispute, it will be more difficult for the court to settle those disputes. But if you have a piece of paper, some writing, signed by party, or you have a deed, even more formal than simply writing, then it would be the court would have some objective evidence to assess whether an interest in land has been created or disposed of. And Section 5.1b deals with trust. Now, the analysis we talked about last Wednesday about the split of legal ownership and equitable ownership in the form of trust. There is only the analysis. And a person can actually declare expressly he wants to create a trust in relation to his land. For example, a father said, I want to put this piece of land belonging to me on trust. The trustee will be my wife, and the beneficiary will be my children. Now, he can expressly do that. And in that case, that piece of land is held under trust by the wife, being the legal owner, or the one who holds the legal estate, and the children being the equitable owners, or person holding the equitable interest. Again, in order to avoid any possible fraud, the law requires that to be in writing, signed by the person. The person would be the one who create this trust. In our example, would be the father. And Section 5.2 expressly said that this requirement of writing does not affect the operation of resulting, implied, or constructive trust. Remember what is resulting trust? If you purchase something in the name of another person, then there is a legal presumption that the other person is holding this property as legal owner and trustee for the benefit of you who make payment of the property. Now, if you're talking about resulting trust, of course, we don't need writing. And the so-called implied and constructive trust will come to this later. But in general, when you see the word constructive, it means the court will construct something, constructive notice. Even though there may not actual notice, the court can say, under these circumstances, I can construct a notice. And constructive trust the same. Even though there is no written evidence that certain person should be the beneficial owner, well, given all these circumstances, I can construct a trust situation, so that the registered owner is holding the property on trust for certain person as beneficiary. We'll come back to this concept in some lectures later. So, any proprietary right capable of existing a legal estate, but not created or disposed by deed, because Section 4.1 requires that to be by deed. If you do not have deed, but as long as you have writing and properly signed, then that particular interest can exist as equitable interest under Section 518. Therefore, now, if we are talking about creating a list for 4 years, now in that case, the exception would not apply because exception require the list to be less than 3 years so that it can be created orally. But when any list which the term of which is, lasts longer than 3 years, it could only be created by writing and signed by the party as an equitable list or equitable tenancy. And if it is not just by writing but by deed, then you would have a legal estate, a legal list. And if the creation or disposal is not in writing, then the transaction is not enforceable in law. Generally, it will not be enforceable in law because it is in breach of either Section 3.1 or 5.1 or 5.5, subject to few exceptions. And the main exception is, of course, going back to the oral list. A term not more than 3 years, marketable rent or reasonable rent, rent reasonably obtainable and without a premium. And any other proprietary rights in land not covered by Section 2 of CPO, for example, land covenant, must create it or dispose of in writing. For example, land covenants. Land covenant is something which was not mentioned in Section 4.1. Therefore, it could only exist in equity. And even though it is an equitable interest, the requirement is it has to be created in writing and properly signed. Now, as I said, one of the difficulties for land law is that one single term has multiple meanings. It is expressly relevant to land law, but not in other branches of law. I'll give you an example. I've mentioned many times about equitable interest. Now, there are at least 3 levels of interest about equitable interest. The first meaning is, the proprietary rights which cannot exist as legal estate. So they can only be an equitable interest in land. For example, land covenant. Section 4.1 did not mention land covenant as one form of legal estate. So you can only exist in equity as an equitable interest. Number 2, the proprietary rights which are capable of existing as legal estate but were not created by deeds. Because under Section 4.1, if you want to create or dispose of a legal estate, you must do it by deed. If you fail to do it by deed, then, but create it in writing and properly signed, then the interest cannot exist as a legal estate, but only an equitable interest. And number 3, the proprietary rights that a person holds in equity under a trust. Remember, trust, we have 2 levels of ownership. The first is the legal estate, which is held by the trustee, and the equitable interest of the property held by the beneficiaries. So at least, we have 3 different levels of meaning when you see the term equitable interest. So you have to be very careful to look at the context this particular term appears, to see whether that term actually refers to 1, 2, or 3. Don't just jump immediately into conclusion. Oh, equitable interest refer to the beneficial interest held by the beneficiary under trust. But in fact, for example, in examination, the examiner actually asking you about the proprietary right which can exist as legal estate, then you will completely off the point. You got 0 mark for that particular question. So same apply to the word estate, right? There are so many different meanings in testing. Therefore, you have to be very careful. Now, after we learn about this formal requirement or format requirement for creation interest in land, including legal interest and equitable interest, let's look at this particular question and see whether you understand the law or law. X claims that he has already agreed to rent his agricultural land to Y, for Y to carrying on rice farming on the land in return for some rice as rent. Was there a binding tenancy agreement? The first thing you want to ask yourself is, now, is it an proprietary right interest in land? Agricultural land. Yeah, apparently it is. What is the general requirement? If it is a legal estate, it must be created by deed. If it is equitable interest, it must be created in writing and properly signed. Now, the question said orally. So, in general, this could not be a binding tenancy agreement, except it falls into the exception. And the main exception would be lease parallel list, a list created orally. But what are the conditions for such an oral list which is enforceable? 3 conditions. Always remember in your mind. Number 1, term not exceeding 3 years. Number 2, market rent. Number 3, without premium. So you have to see whether the description here will give you enough information for you to assess whether this oral agreement would be enforceable or not. Marketable rent. We only know this about rent. Some rice as rent. No, we don't know the duration, assuming that it is less than 3 years, assuming that Y does not have to pay a premium to X. Even if these 2 conditions are satisfied, can you say that some rice is the best obtainable rent for this agricultural land? Well, apparently, or on the face of it, it is not. And in fact, there was a case decided by the Court of Appeal, Chen Yuk Yui and Yu Sui Chi, in which the judge in the Court of Appeal immediately pointed out that this particular allegation of creation of a list could not be supported because some rice is too uncertain. It could never be satisfying the requirement of the best rent reasonably obtainable. Now, in other cases, if it is said that, well, A and B already agreed with B to let, that is to rent, his flat to B for 5 years. Now, once you see 5 years, obviously fall out of the exception. This so-called list could not be enforceable because it's not created by deed or in writing. Okay. this is something that you have to bear in mind after this class about oral agreement. So now if for those young lady, if some man tells you, okay, marry me, I will give you my flat, don't believe it, because that is not enforceable, right? It's not created by this or in writing and properly signed. So you should say, oh, if that's the case, let's write it down. Let's see, sign, seal, and deliver. And sign. Otherwise, this is an empty promise. Okay, we'll come to a new chapter. Now we are getting into more difficult concept of land, co-ownership. What does it mean by co-ownership? Co-ownership of land can be different at law and in equity. At law, of course, it is the format that matters because deed, writing. In equity, it is the reality that matters. Of course, in some kind of equitable interest, we still need writing, but it could be operated by law. In that case, there will be no writing, but it is the reality that matters. Now, in practice, how can we know who is the equitable owner or who is the legal owner? Now, in practice, one can only look at who the registered owner is from the land registry. And, of course, if you are a purchaser, you want to purchase a piece of land, you should not be satisfied with the registration. You should look at who the de facto owner is, if possible. Okay, come back to the scenario we have just I have said many times now. X and Y jointly purchase a property. Now, this time it's not just one person purchases. X and Y jointly purchase a property, but the property is only registered in X sole name. So it is not X purchase the property and register in Y's name, but we have X and Y jointly. So both of them has paid the purchase price, but the property is only registered in X sole name. If you only have this piece of information, can you tell me who is the owner of the property? Would your answer be different if it is only Y who pays all the purchase price? Now, you should start analyze the ownership of land by that concept of trust, the split of ownership between legal owner and equitable owner. Now, you can only acquire equitable ownership by paying the purchase price, or if the property is purchased with the help of mortgage, or then he who pays the mortgage with payment can also acquire the ownership, because that is also referable to the acquisition of the land. So, in the first scenario, X and Y jointly purchase the property. Prima facie, both X and Y are equitable owners and registered in X sole name. So on the face of it, it would be this kind of scenario. X is the legal owner and trustee, and he is holding the property for the benefit of X and Y, who are equitable owners, by means of contributing to the purchase price. Now, of course, this is only one possibility. It could be other possibility. For example, if Y jointly purchased with X, but is actually making a gift to X. If it is a gift, that means he would not claim to acquire any equitable interest in the land. Then we would have X being the only legal owner and only equitable owner. This is, under normal circumstances. Would your answer be different? It's only Y who paid all the purchase price. Then, again, we have two possibilities. X is always the legal owner, but Y can be the only equitable owner, and that is the situation of resulting trust. You pay, make the payment, but register property in other's name, then the presumption of resulting trust would apply. Then we would have X being the legal owner, and trustee holding the property for the benefit of Y, the equitable owner. Or alternatively, although the price is made by Y, it is intended to be a gift to X. If that's the case, we will end up with X being the sole owner as well as sole register owner, as well as the sole equitable owner. So I just have said what I wrote on this slide. Now, when we talk about sale in the form of a trust, we have to ascertain whether this trust is a trust for sale or a bare trust. Now, this is bare trust. X legal owner, trustee, holding the property for the benefit of X and Y as equitable owners. Now, under the bare trust, the trustee will have no duty to do anything, even though he is the legal owner. But if it is trust for sale, then it would be a case in which X has a duty to sell the property in the near future. Now, trust for sale has a special definition under Trustee Ordinance, Cap 29. It is said that in relation to land, trust for sale means an immediate binding trust for sale, whether or not exercisable at the request or with the consent of any person, and with the power at discretion to postpone the sale. So it would mean that when the property was purchased, this Mr. X, as trustee, has the duty to sell the property. And the meaning of immediate binding trust for sale means the trustee in question is given a duty to sell property. And this is a duty which takes effect immediately, but not in the future. And the general understanding or general practice in common law is that so-called immediate duty would be the property has to be sold within 1 year, unless in the trust document. Remember, trust has to be in writing. In that trust document, the trustee is given a power to postpone the sale. And if it's a bare trust, which is the normal situation, trustee does not have a duty to sell. Trustee can only sell the property if he's given a power to do so, and with the consent of the beneficiary. So in these two cases, the duty of trustee and power of the trustees are different. And well, what happens if it is a bare trust and the trustee is not given the power to sell, but it is, in his opinion, in the best interest of the beneficiary to sell the property? Now, if that's the case, he has to get the consent of the beneficiary to sell. If the beneficiary cannot or does not give consent, the trustee has to apply to the court under Section 56 of Trustee Ordinance for an order to approve the sale. Now, there is also practical difference between the two trusts. If the property is held under a trust for sale, meaning the trustee has the duty to sell it within 1 year, under this doctrine of conversion means that the law would go one step further to the legal consequence. Now, since the whole purpose of vesting the property on X as trustee is to sell the property, so the equitable owner's interest is no longer attached to the land, but attached to the proceeds of the sale, the money to be obtained after the sale. But if the property is held under bare trust, the beneficiary's interest is always in the land property itself. So once you are beneficiary under trust for sale, in theory, you no longer hold the proprietary interest in that land. You only have interest in the future proceeds of sale. Thus, for the beneficial owner, it is very important whether property is held under a bare trust or trust for sale. Because if the property is held under trust for sale, the beneficial owner's interest is in the property is in reality the proceeds of the sale. Okay. You don't have to worry too much about the two different trusts, how to distinguish them. Because if you want to have a trust for sale, it has to be expressly declared in the creation of trust. You must have a trust document, and in that trust document, you have to say, this trustee is holding the property for sale for the benefit of the beneficiary. If there is no such express provision in that trust document, then the trust would be a bare trust. And under normal circumstances, the legal owner of the property is holding the property on a bare trust rather than trust to sell. Now, this is one form of co-ownership. We have the coexistence of legal owner and equitable owners who could be different persons, just like in this scenario. Now, look at this fact scenario. We're talking about other kinds of co-ownership. A is taken by an estate agent to view a flat in Sha Tin. B, who claims to be the owner of the flat, opens the door of the flat for A to view. And during discussion, he says that the flat is registered in the name of B's wife as the sole owner. And A is wondering about the identity of the owner of the flat. Advise A. Now you have learned the law to if B is telling the truth, B's wife is the legal owner and trustee, holding the property for the benefit of, B's wife, for the benefit of B, who is the equitable owner. Now, why do we have to worry about this? Because, as I said earlier, one can easily find out the identity of the legal owners of a property by examining the title deeds. If this guy claimed to be the owner, he must have an assignment from a previous owner who transferred the legal interest to this owner. So we look at that, what we call a title document. You can discover, oh, the property was assigned to a Mr. Chen Daiman. Oh, and this guy standing in front of you is Chen Daiman. Then you know he is at least the legal owner. Or simply conduct a land search in the land registry. All legal owners' name would appear in the land registry as the registered owner. The problem is really with the beneficial owner, because it's not always possible to find out the beneficial owner without making proper inquiries. Now, the situation is more complicated if there is more than one beneficial owner. As example here, we have two beneficial owners. Then how can you find out who the beneficial owners are? Now, whenever we have more than one owner holding the proprietary interest of a piece of land or any other real property, in law, we say these two owners hold the interest as co-owner. And co-ownership can exist in two forms, or you can call it, say, there are two types of co-ownership. One is called joint tenancy, and the other is called tenancy in common. That's why I say we are going to more difficult concept of legal ownership. Now, is we have legal estate with equitable interest. In fact, it also has to do with this concept of joint tenancy and tenancy in common. Now, in England, for example, under Section 34 of the Laws of Property Act 1925, a legal estate can only be held under a joint tenancy. A tenancy in common only exists in equity. This makes things difficult for studying English law. But in Hong Kong, we have a more simplified version. There is, first of all, no statutory provision to govern the holding of co-ownership at law. And both joint tenancy and tenancy in common can exist at law, legal estate, and in equitable interest. Go step by step. Okay, look at this question. A and B jointly purchase a house of 2 stories as joint tenants. Okay, when 2 persons or more jointly purchase a property, those persons are co-owners. And they can hold the property in Hong Kong both as joint tenancy or tenancy in common. So in this case, we have A and B jointly purchase the house, and they hold the property as joint tenant. under joint tenancy, and the person are referred to as joint tenants. Now, A and his wife occupy the ground floor. There are 2 stories, okay? B occupied the first floor. Fair enough. A died in an accident, unfortunately. Now, B wants to sell the house because he thought that A's death had to do with the bad feng shui of the house. Fair enough. But A's wife wanted to continue occupying the ground floor. NYC. Okay. Whenever you have 2 persons co-own a property, this kind of dispute may arise. You know, one owner wants to sell the property, the other wants to retain it. What would be? Or in this case, A's wife. Does A's wife have any interest in the land to begin with? Now, we'll come back to this to answer this question after we learn this concept of joint tenancy and tenancy in common. Now, the immediate answer may surprise you. B's wife will have no right whatsoever in the house, because the house was held under joint tenancy. And therefore, it is important to distinguish co-ownership held under joint tenancy and tenancy in common. Because if you opt for joint tenancy, we have a very important legal principle attached to joint tenancy, the right of survivorship. And it means that when one of the joint tenants dies, the interest of the deceased will be automatically passed to the surviving joint tenant by law, by operation of law. This is the concept of right of survivorship. Only when the property is held under joint tenancy, right of survivorship would apply. So in this case, A and B purchased the house as joint tenant, holding the property as joint tenant. Right of survivorship would apply. So in this case, when A died, the property does not go to his wife, but go to B, because B is the other joint tenant of the property. So B always have the right to sell the property, because when A dies, B becomes the only owner, only beneficial owner of the property, and A's wife has no interest whatsoever. And therefore, you have to, after learning the lesson this evening, when you want to jointly purchase any property with anyone, including your spouse, you have to think it very carefully. Now, why you have to think it very careful? Look at this particular question. X and his wife jointly own a flat as joint tenants. Before X died, he met another woman in the mainland who became his mistress. To show his love to his mistress, A drilled a will and left all his property to the mistress. And X died before bringing an action to divorce his wife. Thus, the wife or the mistress get X share of the flat. We should be able to answer, because we have just learned this concept of right of survivorship. Now, but let's go on. Would the result be different if X and his wife died simultaneously in a car accident? And would the result be different if his wife, on discovering X's will, killed X while they were quarreling? Now, when you purchase the property with another person, you'll never think of this possible scenario popping up. And that's why I say after this lesson, when you really intend or plan to purchase a property jointly with another person, you have to think carefully whether you want to register that property under joint tenancy or tenancy in common. Now, going back to this first question. Now, A and his wife jointly owned a flat as joint tenants, so right of survivorship applies. So, when X died, the property, the share of X in relation to the flat will be transferred by operation of law under this right of survivorship to the wife. Now, even though X drew a will, left all his property to the mistress, it could not help the mistress because the interest has already gone to the wife by this doctrine of right of survivorship. Now, this is a lesson to learn first. If someone tells you, now I have a wife, but don't worry, I love you. Now I draw a will. I left all the property to you. So if I die, property goes to you, but not to my wife. Oh, I love you so much. Don't believe it, okay? You ask him first, well, in relation to your real property, is it held under joint tenancy or tenancy in common? Ask him this question. If he say joint tenancy, he say, go to hell. Because those property would not go to you when this guy died. Because the will would have no effect to find any right of survivorship. Now, problem comes. Both person died in a car accident. Then right of survivorship would not apply. Then what happened? What will be the result? Now, under Section 10 of CPO, because this kind of thing did happen in the past, so the English Parliament has made new law, and the Hong Kong government follow suit and become our Section 10. Now, when two persons die simultaneously, it is presumed that the younger person died first. Die later. The younger person died later. The old person died first. So, it would depend on who is older, X or ex-wife. If X is older than his wife, then no problem, because the property will still go to the wife first, right of survivorship. But if X is younger than his wife, then the wife's share of the flat will go to X. Now, X died, so the entire flat would become the estate of X. Oh, then the mistress will get everything, because X left everything under the will to his mistress. Okay? What would be the last scenario? Ex-wife discovered this will. What happened to you? You have a mistress and left everything to her, then out of anger to kill X. Then what happens? Would right of survivorship still apply because ex-wife survived the husband? No. When ex-wife killed X, it is illegal killing. Then the court will treat that as an act of severance. That is to cut off the joint tenancy into tenancy in common. Now, if joint tenancy becomes tenancy in common, then X and wife would be both beneficial owner of the property, and each will have 50% of the property. And X 50% will go to his estate, and therefore goes to the missus, whereas the wife will have the remaining 50%, even though he killed the husband. She may be subject to a life imprisonment, but her right under the property would still belong to her. So, to recap, it is important to note the following points in respect of a joint tenancy. The rights of survivorship in a joint tenancy prevail over testamentary disposition. It's both disposition of property by will, that means. Under a joint tenancy, no single joint tenant holds an identifiable share in the property because all their rights are joined together. So you cannot say, X is the owner of the east part of the property and the wife the west part. You cannot do that because they will jointly own each and every inches or square inches or square cm of that property. Therefore, a joint tenant cannot dispose of his joint tenancy individually by way of a will or otherwise. As a result, he has nothing to pass under a will. On the death of one joint tenant, his interest must be passed to the survivors if there are more than one survivor. Now, severance to cut the joint tenancy into tenancy in common must be made inter vivo. In vivo means life, while the parties are still alive. That means inter vivo. And no disposition of share in a joint tenancy can be done by a will. So the first thing to remember is this. Under Section 11 of CPO, when two or more persons die without knowing actually who died first, it is presumed that death occurs in the order of seniority. The younger one is presumed to die later. Okay? And a joint tenant cannot take advantage of the right of survivorship when it kills the other joint tenant. And that was decided in a rather recent case called Re-K. In this case, a couple owned a house in a joint tenancy, and the wife killed her husband accidentally when threatened the latter by a shotgun. The court held that the effect of killing was to sever the joint tenancy into tenancy in common, and the wife was not allowed to take the husband's share of the house under her right of survivorship. Now, a corporation or company is an artificial person, and under Section 10 of CPO, the corporation is able to acquire and hold any property in joint tenancy in the same manner as if it were an individual. So in theory, you can have two companies or more than two companies holding a property as joint tenants. Or one natural person and a company jointly hold a property. That is possible. Now, then what about the corporation is being dissolved? Now, just like a natural person died, the property dissolved on the other joint tenant by right of survivorship. And at common law, this is under Section 10 CPO, because at common law, a company cannot hold a property as joint tenants on the ground that a company never dies. But now, under Section 10, it is possible to do so. And if the corporation being dissolved, it would treat it as if the company died. Okay, so joint tenancy has this particular feature, right of survivorship. But what constitutes joint tenancy? There are 4 unities for joint tenancy. You must have all these 4 unities existing at the same time in order to hold a property under joint tenancy. And the 4 unities are unities in possession, unities in interest, unity in title, and unity in time. This is also a rather common question in your exam, about the 4 unities. Unity in possession means the possession must do every part of the land. That is, the joint tenants possess together with another joint tenants to every part of the land. No single joint tenant can claim that he is entitled to possession of which particular part of the land. And each co-owner, each joint tenant, may exercise ownership over the whole of the co-owned land and cannot be sued for trespass. Cannot say, oh, this part belongs to me, don't come in, or I will treat you as a trespasser. No, you cannot do that. And the co-owner is not required to pay a rent except where the co-owner ousts another. Oust, that means one co-owner does not allow the other co-owner to enter certain part of the land, turns another out of the property, or prevent him from enjoying the property, such as changing the locks without the letter's consent. Now, we saw some TV drama or movie in which a husband may have make his wife angry, and the wife would not allow him to enter the bedroom. Now, make it for those wives. Make sure that you are not holding a property under joint tenancy. Otherwise, the husband can go to court and sue you for ousting him. Okay. And other features about joint tenancy is each joint tenant is entitled to receive the shares of rent and profits from the property. So if A and B jointly own a flat and they rent the flat out to a tenant, then both of them will be entitled to receive the share of their rent and bound to pay all relevant liabilities. Grant rent, for example, when a co-owner outs other co-owners, the former is guilty of trespass. Okay. So before you say, don't come in, remember this case, who and who. Okay, that is unity in possession. Unity in interest means that the interest of each joint tenant must be the same in extent, nature, and duration. Therefore, when they will differ, the split must be 50-50. You cannot say, oh, 30-70. That would not be a case of joint tenancy. Because they must have, that their interest must be the same. Unity in title means that the title of each joint tenant is derived from the same source. If they jointly purchase a property from a vendor, then the assignment from the vendor to assign the legal interest of the property to them must be the same assignment. And unity in time means that all co-owners must acquire the interest at the same time. Okay, then we come to more technical concept about joint tenancy. If in an assignment it is said that the house was conveyed to X and Y in equal share. Number one. Number two is the house was conveyed to X and Y without any qualification. And number three, X and Y as joint tenants in equal shares. Which form, 1, 2, or 3, is an example of a joint tenancy? The answer is none of the above. No. Because we have statutory provision to govern the creation of joint tenancy. Section 9, subsection 1, whereas tenancy in the same estate or interest in land vested in two or more persons under an instrument or a will. So that is the case of co-owner, two or more persons. It shall be presumed unless the contrary intention is expressed in that instrument of will, that the tenancy vests in those persons as tenants in common rather than as joint tenants. So section 9.1 make a legal presumption that unless you clearly spell out that the legal estate or equitable interest is to be vested on the owners, two or more, as joint tenant, unless you have this particular expression in the instrument, then the interest, joint co-ownership, would be held as tenants in common. And this presumption basically applies to both legal estate and equitable interest. Now, so when you say in equal share, it could not be joint tenants because, unity of possession, unity of interest. Now, if you just say X and Y, then it would not defeat section 9.1 because the presumption is tenancy in common. And what about the third one? We have a contrary expression. X and Y as joint tenant, but in equal share. So we have a contrary expression. Now, how a lawyer deal with this kind of contrary expression? We have to go back to this case. This is a very, very old case called Slingy case. And it is said that under that case, if you have such a contradictory expression, then you will, first of all, ask, where does this expression is found? If the expression is found in the deed, legal instrument, then the first word, joint tenants, will prevail. Will ignore the in equal share. But if this expression is found in a will, the will, in the case of a will, it is always the last will prevail. So the last word in equal share prevail. Or we treat that the testator, the one who draw this will, change his mind. Except as joint tenant, then he change his mind in equal share. If it is a will, if it is normal legal document, then the first concept would prevail. We would ignore the contradictory part, treat it as typo. And if the legal estate of a property is held under joint tenancy, and if the legal joint tenants are husband and wife, there is a presumption that the equitable interest of the property is also held under joint tenancy. And there is this Paul and Mark case. Now, in fact, later on we're going to learn more about when the co-owners are husband and wife, their interests would be quite different from when the co-owners are just friends or whatever. Okay, maybe we'll take a 15 minutes break.